Well, hello again. So, no sooner had I finished putting together the video on Leslie Sloan's motion for attorney's fees and costs, this coming onto the docket as well. We have an order on the Rule 11 sanctions filed by Blake Lively and Ryan Reynolds. So, I haven't actually read it yet, so we're going to do this together. I'm probably going to skip over the background and procedural history because, again, it's the same thing pretty much. Okay. Blake Lively and Ryan Reynolds, defendants in Wayfarer v. Lively, each move pursuant to Federal Rule of Civil Procedure 11 for the imposition of sanctions against Steve Sauerets, Jamie Heath, Melissa Nathan, Jennifer Abel. It ends with us moving, collectively the Rule 11 plaintiffs and their counsel. So that's Freedman's firm and Fritz's firm. Lively and Reynolds seek sanctions in the form of attorney's fees and costs that she incurred in defending the Wayfarer's complaint against her, and a formal reprimand. For the reasons that follow, the motion is granted in part and denied in part. Okay. I might read this. So this just talks about the timeline of events, who filed what and when, what causes of action there were, etc., etc. Okay, so the actual decision. Lively asserts that the first amended complaint was filed for the improper purpose under Federal Rule of Civil Procedure 11b1, obscene a harassing media narrative against her and without any legal or factual basis. She also asserts that in connection with the claims for civil extortion, breach of the covenant of good faith and fair dealing, and tortious interference with contractual and business relations, the Rule 11 plaintiffs violated Federal Rule of Civil Procedure 11b2, which requires that the claims be warranted by existing law or a non-frivolous argument for extending, modifying, or reversing existing law, and Rule 11b3, which requires that the factual contentions have or will likely have evidentiary support. Reynolds likewise asserts that the civil extortion, defamation, and interference claims brought against him by the Rule 11 plaintiffs were legally unreasonable and factually baseless. Rule 11 requires an attorney to certify that 1. A pleading or motion is not being presented for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. 2. The claims, defences, and other legal contentions are warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law or for establishing new law. And 3. The factual contentions have evidentiary support or, if specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. Rule 11c in turn permits a court to impose appropriate sanctions for violations of Rule 11b. Sanctions imposed under Rule 11c must be limited to what suffices to deter repetition of the conduct or comparable conduct by others similarly situated. The sanction may include non-monetary directives, an order to pay a penalty into court, or, if imposed on motion and warranted for effective deterrence, an order directing payment to the movement of part or all of the reasonable attorney's fees and other expenses directly resulting from the violation. Okay. When a court determines that a Rule 11 sanctions are appropriate, it has significant discretion in determining what sanctions, if any, should be imposed for a violation. The standard for triggering sanctions under Rule 11 is objective unreasonableness and is not based on the subjective beliefs of the person making the statement. Thus, an attorney files a pleading or motion in violation of Rule 11 if it is frivolous, legally unreasonable, or factually without foundation, even though not signed in subjective bad faith. It is not a defence that the offending party acted with a pure heart but an empty head. I like that. An argument constitutes a frivolous legal position for purposes of Rule 11 sanctions if, under an objective standard of reasonableness, it is clear that there is no chance of success and no reasonable argument to extend, modify, or reverse the law as it stands. Although Rule 11 provides room for litigants to make non-frivolous arguments for extending, modifying, or reversing existing law, the rule is violated where it is... I'll read that bit again. Although Rule 11 provides room for litigants to make non-frivolous arguments for extending, modifying, or reversing existing law, the rule is violated where it is patently clear that a claim has absolutely no chance of success under the existing precedents, and where no reasonable argument can be advanced to extend, modify, or reverse the law as it stands. The rule is claim and party specific. Even if a plaintiff has a claim against one defendant in a multi-party case, the rule does not excuse him naming other parties as a defendant. Nor, even if one plaintiff has a claim against the defendant, does the rule permit other parties to sue that same defendant absent a factual or legal basis. Moreover, it is not enough, as the Rule 11 plaintiffs argue, that a frivolous claim is dismissed under Rule 12b-6. The evil against which Rule 11 is directed is the burden placed on the courts and parties. The Wayfarer party's first cause of action asserted a claim against Lively and Reynolds for civil extortion. It asserts in boilerplate fashion that the Lively parties, defined as Lively, Reynolds, Sloan, Vision, and the New York Times, made threats to the Wayfarer parties that they knew to be wrongful, that the threats included demands that money, property, services, or other sources of value be conferred upon the Lively parties without consideration or contractual entitlement, that the Wayfarer parties complied with those demands, and that they were harmed as a result. The first amended complaint alleges that in August 2024, Lively and Reynolds demanded that Wayfarer, Heath, and Baldoni make a public apology for the problems that occurred on the set, and that if they failed to do so, the gloves would come off and Wayfarer would be attacked. The Wayfarer parties also alleged that Lively demanded with extortionate threats that Baldoni, Heath, and Wayfarer submit letters to the Producers Guild of America in support of her certification for a PJ mark. The first amended complaint asserts that Lively continued to extort Wayfarer, Baldoni, and even Sony, that Wayfarer and Baldoni firmly resisted, and that ultimately Wayfarer and Baldoni drafted and signed a letter of support on Lively's behalf. I mean, that did happen. We've seen the evidence. It is there. The court previously explained why these alleged threats failed to state a claim for relief against any of the defendants. For purposes of Rule 11, however, what makes the civil extortion claim sanctionable is that the factual allegations do not support a claim for relief by Sauer's, Nathan, Abel, or It Ends With Us movie against Lively or Reynolds. The four of them simply had no basis to sue Lively or Reynolds for civil extortion. The second cause of action implicated in the present motion is the claim for defamation against Lively and Reynolds on behalf of all parties. The claim is based on the allegations that the Lively parties made one or more statements to persons to the effect that the Wayfarer parties engaged in, permitted, and or failed to prevent sexually inappropriate conduct towards Lively and others, and retaliated against Lively and others for reporting the alleged sexual misconduct. The claim is based on the publication by the New York Times of an article that the Wayfarer parties alleged accused them of orchestrating a smear campaign against Lively because of her allegation of sexual misconduct on the set of the film, and the allegation that by telling the New York Times a false and damning story about an insidious PR sabotage operation deployed as revenge for sexual harassment complaints, Lively and her co-conspirators committed the tort of defamation. Reynolds argues that the claim against him is sanctionable on the limited basis that it does not allege that he personally made any defamatory statements to third parties. But a party can be held liable for defamation under New York law on a conspiracy theory. Reynolds' motion directed to the second cause of action is therefore denied. The Wayfarer Party's fifth cause of action asserted a claim against Reynolds and Lively for intentional interference with contractual relations. Their sixth cause of action asserted a claim against the two for intentional interference with prospective economic advantage. And the seventh cause of action asserted a claim for negligent interference with prospective economic advantage. Each of the causes of action is based on an alleged contract or economic relationship between the Wayfarer parties and WME. WME is alleged to have represented Baldoni and Wayfarer. The Wayfarer parties allege that Lively and Reynolds interfered with the performance of the contract with WME. Again, we've seen the evidence. And negligently or intentionally disrupted the economic relationship with WME, including by making threats and or demands that WME terminate its economic relationship with the Wayfarer parties. The claims are based on the allegation that Reynolds approached Baldoni's agency, namely an executive at WME, and expressed his deep disdain for Baldoni, suggesting that the agency was working with a sexual predator, and at a later date demanded that the agent drop Baldoni. The Wayfarer parties have not identified even an arguable basis in law or fact for any Wayfarer party other than Baldoni and Wayfarer to assert these claims, as no other party was implicated in the contractual relationship. So before I continue, I will say I do actually agree with that, right? So he's saying, well, okay, if that's true, that should have no effect on... I mean, it's arguable to say that potentially Sarowitz and Heath... well, Sarowitz co-owns Wayfarer, but Wayfarer is a party in its own right. So, yeah, so Heath and Sarowitz as individuals are not affected. Abel and Nathan certainly aren't affected. So why were they all suing Lively and Reynolds for a contract that they were not party to? And I can understand that. When it comes to the law, Judge Lyman's right. So he is saying, well, actually, it's plausible that Lively and Reynolds did interfere with the economic relationship between Baldoni and Wayfarer and WME. But the other Wayfarer defendants were not, they didn't have an economic relationship with WME. So why were they suing? And I do think that's where the drafting of the complaint was kind of sloppy. You can't just because you're representing like multi-party defendants does not mean that you can just kind of, state causes of action on behalf of all of them, even whether or not they're affected. And that's what Lyman is saying here. Okay, finally, the fourth cause of action, which was pled only against Lively but is asserted by all the Wayfarer parties, alleged that Lively and the Wayfarer parties entered into a contract by which Lively agreed to perform as an actor in the film, and that she engaged in conduct that deprived the Wayfarer parties of the benefit of that contract, and thereby breached the duty of good faith and fair dealing. But there was no conceivable basis upon which to allege the existence of a contractual relationship between Lively and Sarowitz, Nathan, Abel, or Heath. Yeah. Again, it would be, whilst, everyone would be saying, well, hold on, Heath and Sarowitz, they work for, they work for Wayfarer or they co-owner of Wayfarer. Again, it ends with Us movie and Wayfarer are their own defendants here. So this is talking about these people as individuals. And again, he's right. A claim by a person that the defendant has committed a tort or breached a contractual relationship is not to be made lightly. it can carry reputational consequences, even if that same claim is properly made by another party. The court is authorised to impose monetary sanctions, including a penalty or attorney's fees for such conduct. In this case, however, there is no basis to believe that the allegation of the sanctionable claims imposed any great burden on Lively and Reynolds beyond the burden that they face to address the claims which are not sanctionable. The sanctionable claims did not place any burden on the court. Accordingly, the court limits the Rule 11 sanction to a reprimand of Lina Freedman and Mr. Seelig and their respective firms for violating Rule 11. So to explain that, what Judge Lyman here has done is quite clever. It's quite crafty, actually. He's given Lively largely the bare minimum of a granting of her sanctions request. So what that means is he has basically said he has not sanctioned the individuals, the Wayfarer defendants personally. He has sanctioned the two law firms, and all he has done as far as sanctioning them is basically say, you naughty boys, don't do that again. He's just basically, kind of reprimanded them. Said, right, don't do that again. There is no fees to pay. There's no monetary sanctions, penalties. There's nothing else. So Lively can't now complain that she didn't get her way with these sanctions. But he has given next to nothing, and what he has given actually makes a lot of sense. So, okay, this is not devastating. This is not devastating. It does make sense because there was a bit of sloppiness in the drafting of the Wayfarer complaint, but I maintain, as I always have, that first amended complaint by Wayfarer was designed to win the PR war again and to get the tides turning, to get the evidence out there in whatever way they had to do it. It did not look like an actual complaint. It was not drafted like one. So, but neither was Lively's. Lively's definitely seemed to be just for headlines. But then Freedman I think he was tasked with the objective of getting the public to look at the evidence, hear the other side of the story, and get them back on board to, supporting Justin Baldoni, supporting Wayfarer and the other defendants again. And he did that successfully, incredibly successfully. So I think, okay, he's taken a little bit of a hit here, but it's barely touched him in all fairness. It's hardly chinked the armor. So I'm not concerned about this, but I know the judge is he's given a sleight of hand. He's basically saying to Lively, yeah, okay, I'm going to grant your sanctions request. But in reality, she's got nothing from it at all. Nothing. Other than what we already knew, which was that, it didn't make sense for all of the Wayfarer defendants to be claiming things that they didn't personally have a claim to make. So, whilst it looks like a win for Lively, and I'm sure the newspapers will be touting it as one, it's really not. And it's definitely not a win for Reynolds because his request was denied. So all in all, more good news. I feel like I'm gonna say it again. I do feel like Lyman is getting his house in order, ready for the big dispositive motions. So this could be a long night. So I'm sure you'll probably hear from me again.